Surrey Panorama.
Mr. Speaker, honourable members, I rise today on second reading of Bill 12, the Safe Access to Schools Amendment Act 2026. This bill proposes simple but consequential change. It extends the repeal date of the Safe Access to Schools Act from July 1st, 2026 to July 1st, 2028. While the intent behind the original legislation to protect students and educators from genuine harm is admirable and one that every member of this House shares, I cannot support its extension without the most rigorous scrutiny. The principle of safe, uninterrupted access to our K-12 schools is not in dispute. Students deserve to learn free from intimidation, disruption, or fear. Yet in this Act, as implemented and as proposed for extension, has raised profound and unanswered questions about proportionality, demonstrable effectiveness, charter rights, and jurisdictional overreach. And I will probably vote in favor of second reading solely to advance the bill to committee stage, where we can demand precise answers on its real-world application. But forgive me if I find the government's position a little disingenuous, as they seem to find wearing shirts threatening people they disagree with to these very school grounds about our children. While we explore the sufficiency of less intrusive alternatives already enshrined in the criminal code and rigorously safeguard the fundamental freedoms of expression and assembly that define our democratic society, let us begin with the facts as presented by the government. The Safe Access to Schools Act, passed in 2024's Bill 22, established a 20-meter access zones around every K-12 school, encompassing the school property itself and a legislated buffer zone beyond it. These zones are active 7 a.m. to 6 p.m. on school days and during extracurricular activities. Within them, the Act prohibits a sweeping list of behaviors impeding access to or egress from the school, disrupting educational programs or extracurricular activities, participating in a protest, which is important to note, we'll get to that, engaging in interference, which is broadly defined as advising or persuading anyone to refrain from participating in or providing an educational program, and intimidating or causing reasonable concern for a person's physical or mental safety. Police are empowered to arrest without warrant on reasonable grounds. The Act also allows for injunctions and includes limited exemptions, like lawful labor actions under the Labor Relations Code and certain work activities. The government's narrative is one of preventative success. They tell us since 2023, there have been more than 40 protest disruptions outside K-12 schools, sometimes requiring police intervention. And I would highlight the sometimes requiring police intervention. They claim the frequency has fallen since the SASA's enactment, using this trend to justify the 2-year extension. Yet, Mr. Speaker, when we move from government assertion to verifiable fact, a striking and telling absence emerges. A thorough review of public records, news reports, and answers to order papers questions reveals there are no documented instances of arrests, tickets, or charges laid specifically under this Act. No parents have been publicly reported as arrested for voicing concerns at their own children's schools under these provisions. The primary, and perhaps only, publicized interaction involves protesters at school board offices, administrative buildings separate from children, who were warned to move along with the Act cited as authority. This application affecting citizens, protesting funding and policy decisions before their elected trustees, clearly falls outside the stated spirit of protecting children at school grounds. It reveals the Act's utility as a tool for managing dissent in the broader education ecosystem, not just for safeguarding schoolyard gates. The government cites a decline in disruptions, but offers no transparent, auditable data on how or whether the Act's unique and powerful provisions were ever invoked to achieve this. Could it be that these numbers at the time were high because it was on people's minds and has since gone down? Does it have anything to do with this Act? Police have always possessed general authority to address genuine threats, trespass, mischief, intimidation, or obstruction under the Criminal Code, and then common law powers to prevent breach of the peace. I know many times those tools were what I used as a police officer in instances just like this. If the Act has not produced a single reported enforcement action in nearly 2 years, one must ask critically, is it truly preventing imminent harm that existing law could not? Or is it casting a broad, chilling shadow over peaceful expression, achieving compliance, not through the use, but through the threat of its poorly defined powers? This brings me to the heart of my concern. While protecting students from tangible harm is paramount, this legislation has not demonstrably been used for that purpose alone in any documented case. Instead, its dangerously broad and subjective language prohibiting not just violence or the physical blocking of doors, but the act of participating in a protest or anything that could reasonably be expected to cause concern for a person's physical or mental safety. It creates a high risk of silencing legitimate parental voices and community dissent. Parents have not just a role, but a fundamental right and responsibility in their children's education. And all too commonly recently, that has been pushed aside. School board decisions on funding, curriculum, library resources, or staffing cuts directly affect families and communities. Peaceful, lawful protests at or near school boundaries, even if passionate or dissenting, are a cornerstone of democratic engagement and civic accountability. The official opposition believes strongly in the right to assemble peacefully, a freedom enshrined in Section 2C, the Canadian Charter of Rights and Freedoms. We also cherish the freedom of expression under Section 2B. Access zones, which some have rightly called bubble zones, can effectively prohibit the exercise of these rights in public spaces, even if that is not the stated intent. Consider a real-world scenario. A parent distressed by the closure of a neighborhood school or a radical change to a cherished program stands 15 meters from the school gate on a public sidewalk at 5 p.m. holding a sign that reads, "Keep our schools open." Under this legislation, if an extracurricular event is underway, that parent could be deemed to be participating in a protest within the zone or causing concern to someone entering the building. This is not a hypothetical overreach. It is the logical, foreseeable consequence of the Act's sweeping wording. The law creates a mechanism where subjective discomfort can be conflated with objective threat. I would bring up an instance where somebody says their child is upset seeing a crowd of people at school. Does that create a problem? Or has that now become a crime under this legislation? To understand the implications, we must compare this bubble zone precedents the government itself invokes. So in 1994, British Columbia enacted Canada's first bubble zone law, the Access to Abortion Services Act. It created buffers, 10 to 50 meter zones around clinics, doctors' offices, 160 meter zone around the homes of providers, and 50 meter zone around the homes of staff. It specifically banned protesting, besetting, harassing, filming, or even attempting to persuade within these zones. Offenses carrying clear fines of up to $2,000 or 6 months in jail. That legislation was a response to a specific, at that time intense, context of harassment, intimidation, and violence targeting vulnerable patients and healthcare professionals at very specific, identified locations. It was narrowly tailored to an acute crisis. The Safe Access to Schools Act, by stark contrast, applies blanket, one-size-fits-all prohibitions across every public and independent school in the province. Over 1,500 sites, regardless of whether a single incident has ever occurred on that site. And it lacks the penalty clarity of its 1994 predecessor. Enforcement relies on a patchwork. Reference to the Offense Act and the Violation Ticket Administration and Fines Regulation, which sets $2,000 fine per contravention plus a $300 victim surcharge for if you can get a ticket for $2,300. Arrest without a warrant is authorized. Yet the Act itself contains no standalone penalty provisions, only the power to restrain contraventions by injunction, whether or not a penalty or other remedy is provided, quoting. This creates profound legal uncertainty. Is this a regulatory ticketing matter or something more akin to criminal prohibition? This ambiguity is a recipe for arbitrary enforcement and a shield against accountability. The jurisdictional questions are equally pressing. The government has simultaneously tabled, sorry, I'm going to skip that portion. The government has changed other legislation. A telling criticism of distinction emerges in those changes. In other legislation, the clause explicitly prohibiting participating in a protest has been removed. I would suggest this omission is a tacit admission by the drafters that such a blanket prohibition on protest in a public space would not survive a charter challenge. One must then ask, why does that same, likely unconstitutional clause remain in the Safe Access to Schools Act? Is it because the government believes the right of parents and citizens near schools are less worthy of protection? Or because this law just hasn't been legally stress tested yet, due to its lack of use? Meanwhile, at the federal level, Bill C-9, introduced this past October, amends the criminal code to prohibit the display of Nazi symbols, SS symbols, and other hate symbols in public, with exemptions for journalism, religion, education, and art. It adds aggravating factors for offenses motivated by hate and creates a specific offense of intimidation at buildings used for religious worship. But notably, it does not establish fixed distance bubble zones. The federal approach is conduct specific. Intimidation must occur at the place of worship. It targets harmful behavior, not geography. and it does so under the clear federal jurisdiction over criminal law. And this applies directly to the schools and places of learning that this act is referencing. Why then does this provincial government feel compelled to create hundreds of provincial bubble zones that encroach on what is fundamentally a matter of criminal law? Intimidation, criminal harassment, obstruction, and mischief already comprehensively addressed under the criminal code. This appears to be provincial overreach, duplicating and potentially conflicting with tools already available to police and courts, and doing so with a less precise, more rights-infringing instrument. Mr. Speaker, the Charter is not a suggestion. It's the supreme law of Canada. Section 1 allows for reasonable limits on rights, but only if they are demonstrably justified in a free and democratic society. The government has not met that onerous test here. They cite the 40-plus disruptions since 2023, many of which predate this act and were centered on debates over SOGI curriculum and other policy issues, but provide no breakdown distinguishing between violent or criminal acts and lawful, peaceful protests. They claim success because disruptions have fallen, yet refuse to disclose whether this decline is due to this act, changed public sentiment, increased police liaison, or the simple fact that the peak of a particular social debate has passed. In the absence of enforcement data, the claim of cause and effect is speculative at best. Therefore, the committee stage must be an exercise in forensic accountability. We must demand exact and verifiable statistics on all invocations of the Act. How many arrests without warrant? How many tickets issued? How many injunctions sought? We require the file numbers, dates, locations, detailed case studies and disclosures. Were any of these actions taken against parents at their own children's schools or against protests specifically concerning school board cuts, staffing, or curriculum? The Attorney General must provide anonymized summaries. Evidence of insufficiency. The Minister must table specific incident reports from before the SASA's enactment, where police were unable to act under existing criminal code provisions. Reference Section 423 on intimidation, 264 on criminal harassment, 430 on mischief, 120 on obstructing a police officer. Or common law powers necessitating this new law. Justification for extension without a review. Why are we extending a sunset clause on a powerful law without first conducting an independent, arm's-length review of its necessity, effectiveness, and charter compliance? Should that review not proceed, not follow an extension? Consideration of narrow rights preserving amendments. The committee must explore explicit carve-outs for peaceful parental expression. Distance-based distinctions, example of a small buffer zone for pure protest, or a mechanism where zones are activated only by court order upon application showing a specific credible threat at a specific school, a surgically precise tool instead of a provincial blanket. Colleagues, this is not about opposing student safety. It's about ensuring that safety measures are necessary, proportionate, effective, and minimally intrusive upon the democratic values we are entrusted to uphold. The right to assemble peacefully and express dissent is not a threat to education. It is its very foundation. A society that teaches civics in the classroom but criminalizes its peaceful practice on the public sidewalk outside sends a devastatingly contradictory message. History shows that bubble zones, while well-intentioned in narrow specific contexts, can, over time, become tools to marginalize unpopular views and sanitize public discourse. Once established, the boundaries of such zones only ever seem to expand, and their prohibitions multiply. I will support sending Bill 12 to committee, not because I endorse the extension, but because this House owes British Columbians a transparent, evidence-based debate before entrenching this law for another 2 years. Let us use the committee to question the Attorney General and the Education Minister rigorously on the Act's real-world track record, not its theoretical benefits. And I've laid out questions that I will be pushing to ask in the committee stage. Hopefully there will be answers. Let us compel the government to finally provide the data it has withheld. Let us examine whether federal criminal law, properly resourced and enforced, already equips police adequately. Let us be prepared to amend the legislation significantly to protect both physical safety and foundational freedom. In closing, Mr. Speaker, all students have the right to safe access to school grounds, but parents, educators, and citizens also have the inviolable right to peaceful assembly and expression in public spaces. The official opposition will always defend both. We look forward to a committee process where facts, evidence, and constitutional principle, not fear or political convenience, will guide our ultimate decisions. And I want to finish up off what my colleague before me had said from Richmond Queenborough about being properly served in this province, because province-wide, we are not being properly serviced by the police and by the courts. And that is what leads to laws like this needing to be put in place. And by needing, I say a little sarcastically, I guess, because we should not need these with the current laws that serve us under the Criminal Code of Canada. Time to start dealing with the real issues. Thank you, Mr. Speaker.